Well, thank you very much for your question. It's a pleasure to join you today. I think that pledge then needs to be given a specific contractual setting in the context of which then the parties will also agree to settle any disputes arising out of or in connection with those contractual rights and obligations through arbitration or another form of ADR. And that is where ICC Dispute Resolution Services actually comes in. It creates a neutral forum within which those disputes can be managed, avoided, and ultimately, if that fails, settled. I emphasize the point on neutrality. There is a second point that actually goes to the flexibility of process, so parties are completely free to determine the main characteristics of the process that they want to see followed in order to resolve their disputes, and also rely on the century-old experience of the ICC court or the ICC ADR Center in helping them reach that goal. But even beyond that, and even beyond the stage of the dispute, I would like to mention that, especially when it comes to climate goals, there are important changes, I think, that might come in the context of specific contractual provisions that we will see in investment contracts. And there is work currently underway by the ICC Institute of World Business Law and Unidroit in actually creating specific clauses that parties can insert in their contracts when it comes to investment contracts with state-owned entities. Well, in many respects, the world today is vastly different from the world in 1919 when ICC was established, or 1923 when the ICC court was created. But at the same time, there are important similarities. And that is why that mission remains quite the same today as it did, and potent today as it did 100 years ago. I would say that the way that we actually implement it is by approaching it as our duty to secure access to justice and the rule of law. And that is basically how we have taken forward that pledge by the Merchants of Peace to actually ensure that our dispute resolution processes will remain effective and serve party needs. Well, our approach when it comes to supporting the needs of businesses, states, and state-owned entities is really to understand what those needs are and not make assumptions on that basis. And also our offering is not one that has any ulterior motive to bring cases to the ICC in Paris. It really creates a system of case management where the parties themselves define the parameters. And that is why we decided many years ago to move from a very centralized system of case management administration, everything out of Paris, to a more decentralized system. And that is why today the Secretariat of the Court has offices in Paris, in New York, in Sao Paulo, in Hong Kong, in Singapore, and of course in the Middle East here, in the Gulf, in Abu Dhabi. So we understand the needs of the parties because we are in close proximity with them. We understand the needs of the parties because we have industry-wide knowledge and expertise. We understand the needs of the parties because we are in constant discussion and engagement with them. We understand the needs of the parties because the staff that actually takes care of their cases has experience and expertise in the jurisdictions that they are active in. So for instance, to take the example of MENA, the case management team in Abu Dhabi is composed of colleagues from the region. The team that takes care of cases out of Africa, be they Anglophone or Francophone, includes members from the region that have been trained in civil law and in common law traditions, and so on and so forth. So when one speaks of legal reform, I think the aspiration is that that reform always creates a better legal framework, legal system for arbitration, and I think that is what has happened in most of the cases in which you've mentioned. In those cases where I think legal reform touches upon other aspects and not just arbitration law, one, of course, needs to be able to weigh the opportunities for or the challenges on the way of a better arbitration framework and a better arbitration experience for everyone concerned. The way that we have managed actually to stay ahead of that is engage with the authorities that are contemplating those changes, for instance, both in France and in the United Kingdom, as also is the case in other places such as Qatar, Saudi Arabia, and also Singapore. There has been active engagement and a consultation process in which institutions such as ICC, formally or otherwise, participate. There are other instances where that avenue may not be readily available, but the ICC network has access, and that is what happens with well-functioning, active, dynamic national committees. And that, again, is the example of ICC Mexico. So I think by utilizing the resources across the network and, of course, the expertise that we have and the experience that we have through managing now close to 30,000 cases, we can actually contribute to the betterment of the systems that are going through a reform process, but also ensure that our own offering remains relevant in those settings.